The public showed little interest in a public hearing Thursday morning on a proposed amendment to the state's constitution that would change the requirements for recall elections.
Under this amendment, an elected official may only be recalled if he or she has been charged with a serious crime or if a finding of probable cause has been made that she violated the state code of ethics. As always, this constitutional amendment would require passage of 2 consecutive sessions of the legislature and a referendum by the people.
Democrats at the hearing made some interesting points.
Wisconsin has among the toughest recall laws in the country. Did you know that? The people have had this right to launch a recall effort since 1926. So for 86 years, the people have had this right. Do you feel that we are trampling on the people's rights with this constitutional amendment to rescind that right for the people to have a true recall?
No, I feel we're clarifying the reason of why we should have the recall. And I don't feel that's trampling on their rights. I look at it again as everything else that we do here, looking for a clarification of purpose.
Do you think that an elected who allowed to have maps, redistricting maps drawn in secret, I mean, is that an offense that where you believe a recall effort, should be launched by the people if maps were drawn in secret, redistricted maps for the state?
I'm not a lawyer, and I'm not going to go by hearsay, so I'm not going to answer that question.
What about an elected officer who paid private lawyers $300 an hour with taxpayer money? Do you think that that elected officer then deserves to have a recall launched against him by the people? And lastly, an elected officer who has their staffer write secret talking points. How about just something more general, like we will never again mislead or lie to the public or have secret agreements with lawyers to hide the truth from the people?
If you're on the committee for the Code of Ethics and you want to put that in, that would be able to be discussed.
I hail from Milwaukee County, and my former county executive is Governor Scott Walker.
Mm-hmm.
And he was elected in a recall in 2002. He was elected in a recall election.
He was elected in an open election. It wasn't a recall.
There was a recall of Tom Ament. He won in a special election.
There was a special election. The county executive resigned. It was not a recall election.
It was a recall.
It was a special election for an open seat because the county executive resigned. County Exec Ament resigned. Therefore, there was an open seat and there was a special election.
He resigned after he was recalled.
So did Senator George. As we were stated earlier, he didn't recall. Yes, Senator George was recalled. He resigned.
How much will the recall cost us again, Representative Farrell?
Which one? The current ones that we're looking at?
The $9 million, didn't you say it's going to cost?
The Government Accountability Board came out with an estimate saying that if the recalls on a 1 day of recall would roughly cost $9 million.
And how much did we cut from our public schools in the biennial budget?
A little bit more than that.
$800 million. Per year. The biggest cut to public schools that I've seen in my lifetime, probably your lifetime as well.
First of all, Representative Farrow, I can understand your concern about the cost of the GAB having to review the signatures, but I would submit that the easiest way to avoid that would be for the governor and lieutenant governor to simply stipulate that when you've collected almost twice the number of signatures that are required, there's no way that they can overcome that, and they should just, accede to the fact that, they're going to be recalled and there's going to be an election, and that would save a significant amount of money.
So basically what you're saying is just because we have 1 million signatures, we should assume that it's going to be done. There shouldn't be any jurisprudence, any look at what the signatures are, who wrote the signatures, if it was done properly. You're just saying that we should give it up and, hey, we've done it and we should move on?
Well, I'm just saying that when you reach a threshold of having almost twice the number of signatures that are required, it's incredibly unlikely that you're going to be able to knock somebody off the ballot. Or like whether you're talking about nomination signatures or recall signatures, when you're at double the threshold, it's the governor's option whether he wants to challenge the signatures. He has every right to do it. But if the concern is about cost, and I know the governor has spoken a lot about that, the easiest way to save that cost for the taxpayers is just to say, okay, you guys got 1 million signatures, even if 30 or 40% of them were invalid, you still have enough signatures to trigger a recall, and
Representative Paul Farrow, who co-authored the bill, ended his public testimony with an editorial from 1926, the year the state's constitution was amended to allow recall elections.
A gentleman named I.J. Nash, who was an attorney for Manitowoc and served as the reviser of state statutes at the time, urged Wisconsinites to reject the amendment. Paraphrase, he gave this warning. Such a constitutional provision would make Wisconsin the laughingstock of the country. A recall proceeding is slow, conducted with passion, expensive, sets neighbor against neighbor, is unaccompanied by sworn or other competent evidence, and convinces few that justice has been served. Time seems to have proven Mr. Nash correct.
For the McIver Institute, I'm Bill Osmolsky.